you go down. Don't give any cause for that to happen. So for now, I'm gonna have you sign a reset with Victoria. We'll have you take a seat in the jury box. I'm gonna find your lawyer, and then you tell your side to the lawyer, and then we'll go from there. He can always, or she can always reapproach, and we can talk about how to go forward. All right? Please.
That's it for now, Judge. Go ahead and sign for your reset.
Counsel. Hey, good morning.
Go ahead and sign for your reset.
I'm here on Brianna Treadwell.
Reach out behind you. All right, count for reset.
Okay. Yes. Are you going to retain?
I am retaining her.
Got it. Okay.
I would file a motion, so that's contacted yesterday.
Okay. What would you like, counsel?
I know the circumstances.
I'm okay with doing that some. I'm okay with it. But I'm not, it's not gonna go crazy low, you know, but I am willing to do that. I think it's high, but I wanted her to understand that we need business and that we're absolutely serious. So do you have a recommendation? What do you think, guys? He wants a bond reduction on Treadwell, and I'm for it.
5,000, Judge.
Each? No, that's too low. Not when you have two open DWS. Yeah, I was gonna do 10 each.
I think that's appropriate.
And then if you still have an issue, come back, we can talk. But I'm gonna put, if she's able to bond out, I'm gonna put a whole host of conditions on her.
That's
You know, like
understood.
she's not out to be in the middle, no, out in the middle of the night, you know, curfew, no driving, and then, you know.
And that's even contingent upon the occupational license.
Oh, I'm not, she's got two, I'm not giving her an occupational license. Are you kidding? She got two open DWIs. Mm-mm.
She has to work. Well, and
She
then
gets into a car accident. She's drinking while she's driving. Her prior case is a .289. She's no way, and understand, counsel, whenever I have anyone that has picked up a DWI with another DWI, I take away the privilege to drive. I just can't trust you. And especially at that high amount, something else is going on. And I just don't want her to kill anyone, you know?
And I have an idea of what is going on. You know, she has some mental issues. She's taking all this medication that needs to be adjusted because she's having trouble sleeping. And then when it's not time to sleep, trying to operate, you know, she's sleepy then. So that's that wrong time. So she does need to get something.
How old is she?
She is 31. 31.
Who does she live with? Is she married? Does she have kids?
She has two kids,
She's got
4
a
and
drinking
11.
problem.
4-year-old has autism, has occupational therapy, I believe 3 times a week. You know, 11-year-old, smart as a whip, just won the school spelling bee. You know, it's a bad situation that she has herself in, and as far as the circumstances that she does have at home, of course, it's totally
Second.
different.
Those
Can you
problems
bring up
might
Ms.
be
Treadwell,
related.
please?
Yes, Your Honor.
Thanks.
Cervantes. Denaro.
Come on down. Next contestant. Say some crazy stuff.
we have-
Yeah, but I get you.
I got a stream going on
Hey,
here.
let me talk to her in the morning. Who's the interpreter? Hey, Elise. I didn't see that. Give me a second. Let me talk to him, see what, counsel, can I help you out while we're waiting?
Mr. Earl, bond violation.
That's gonna take a little bit of time, actually.
It was just his first visit, first court date he was sent for. Yeah. He's scheduled for November 18th. He said he will be clean by that time.
Is it Rolando?
I'm fantastic.
Earl?
Thank you.
Skylar Earl.
He failed a UA judge.
The last,
Right. Okay. Come up, Mr. Earl.
My only issue is there's a little rain in my part of the world at the moment. But no worries, it'll pass right over.
I'm making it a condition of your bond that you're not to use anything. And I'm going to test you again in 40 days. If I find that you test positive again, it tells me that you've continued to use, and I'm going to put you in jail, and I will not give you any more PR bonds. Do you understand? No more using. Don't pick up any new cases. And I think that I've taken away his privilege to drive as well, right? Yeah, because it's his third or second racing case. Yeah. Okay. You're on notice now. No more violations. And if you fail to go to another UA, likewise, I will revoke your bond. Do you understand? Okay. We'll set your case off 40 days. Okay. Thanks, counsel.
All right, I adjusted my volume a little
Okay, you
better.
ready? Good morning, Ms. Treadwell. How's jail? You know, your lawyers come up to me and ask for me to reduce your bond. I've got your bond at a very high rate, you know, $50,000 for a reason. I want you to understand that we mean business. It's not a joke. When you're out there and you're driving in a state that can, very well, you may do something that can cause catastrophic damage and you'll never dig yourself out of a hole. I will reduce your bond. They asked me for 5, I'll do 7,500 each. But I'm telling you, if you do get out, no more issues. I want you on the curfews, and I don't want you out in the middle of the night, and I definitely don't want you driving. Do you understand?
Thanks,
You're gonna have to
greatly.
find another way to make it work, but not in a car. I just can't trust you. You have a lot of people that depend on you, 2 children that depend on you, right?
I'm not saying I
When
don't
you're
trust
not
you.
there, they're gonna look to love and support from somewhere. And if you're not there, they may look to it at places you don't like or you don't approve of.
But I
These
don't
are
trust
things
you.
that you need to consider. When you become a mother, your life's not yours anymore. It's your children's lives. That's who matters. So when you're out there considering doing what you're going to do, the only thing that needs to come in your mind, if I do this, how is it going to impact my kids? That's what you need to be thinking about. Do you understand, man? Yes. Okay. I'll make it 7,500 each. Okay. And then if you're able to bond out, you must come here immediately so we can do all the bond conditions, do all the paperwork, because I'm putting an ankle monitor on you, so I know where you are. And I'm on your other ankle, I'm going to put a scram, so I know that you're not consuming alcohol. And I'm going to tell you now, you bond violate, you consume alcohol again. You pick up a new case, holy, I'm going to go nuts on the bond. Do you understand? Okay, Mr. Treadwell, good luck. Okay, guys. Thanks. Thank you.
In fact, you'll flip.
Counsel, are you ready?
You should know.
Yeah, okay.
Judge, you ready for the first
Oh,
arraignment?
yeah, let's do it. So 7,500
Page
each.
475. Armio
75,
Jimenez,
7,502 each.
75.
Yeah.
Judge, don't forget Mr. White.
Oh, Brock? Yeah, I'm sorry. I'll do Brock right after these 2. Brock, I'll hit you up after I do these, okay? Apellido. Jimenez. Jaramillo Jimenez, you were charged with driving while intoxicated. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present.
All will be
If you cannot
revealed
afford one will be
at
appointed
some
to
point
you,
on
sir.
Vlog Talk with Mike. is my guess.
On October 28th, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it operate without
Well,
all
not
of its
all.
lighting
You know
equipment
what I'm saying,
activated
like,
during the
location.
nighttime. Upon contact with the defendant, who is the driver and sole occupant, officers observed the suspect to have slurred speech, bloodshot eyes, and an odor of alcoholic beverage. Defendant admitted to drinking 2 alcoholic beverages about 1 to 2 hours prior. SFSTs were conducted, 6 out of 6 HGM, 7 out of 8 walk and turn, 2 out of 4 one-leg stand. DICs were read, but breath was refused,
Drunk
and a
as
search
Scooter
warrant
Brown.
was signed and executed.
They can just summarize it with that.
The defendant does also not have an eligible driver's license, Judge.
Again, we have to go on an offense writing report, just class. I mean, it's completely conclusory. Read me the first sentence. Why the PC for the stop?
Read from the DIMS really quickly, Judge. I just want to make
Oh,
sure.
here we go.
it's Correct.
Without all of its nighttime equipment on. What on earth does that mean?
See if we can read it from.
Read the statute,
Do we have
Judge.
the offense report, Judge? Because that's what
It's
it's. DIMS.
over and over and over and over. Headlights, brake lights, turn lights.
Yeah, people get pulled over for that all the time. It's not a good look to sit there and say that violations of the law should be ignored for a judge.
I'm just
Knock
seeing
it
in the
off.
offense report, Judge, that driving without lights activated during nighttime.
Driving without lights activated is the telltale sign
Better.
of drunk driving.
So
Known
you're saying
throughout
you're
the country.
driving at night without headlights? Is that?
That's what I believe this offense report is stating. It doesn't specify which lights.
I mean,
This isn't close. Let's stop pretending it is. He'll come around. He realizes he's out of line. That's all you need. If you have a picture of that, it's over.
yeah, I guess I'll give you a bit of time, for,
Straight
you know.
conviction.
Just toma asiento allá, por favor.
The next Spanish word is page 21, Ponce, come on up.
Chief was just looking at the body cam, at the dash cam, and he has no lights on, headlights or tail lights.
No tail lights, Joe. All the tail lights are completely gone.
Does that do it for you? How about protect the public? That'll be enough.
Once you're charged with driving while intoxicated, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On October 27th, 2024, officers conducted a traffic stop on the defendant's vehicle on the Tomball Tollway after observing it swerving within its lane, unintentionally drift into the lanes beside it, and nearly strike another vehicle on the roadway. The vehicle also failed to signal a lane change. Upon contact with the defendant, the officer observed the defendant to have slurred speech, glossy eyes, and a moderate odor of an alcoholic beverage. The defendant admitted to driving and to drinking 2 large beers, one of which was found on the back passenger floorboard, a quarter of the way full and still cool to the touch.
So drinking while driving?
And standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, one leg stand 2 out of 4. The DIC was read and the defendant consented to breath. The breath samples were 0.089 and 0.091.
Mr.
Oh,
Ponce, I'm gonna find that there's probable cause to go forward with the case.
oh,
You're in this country with or without permission.
Without permission.
What happens if you go to jail?
Nothing.
No, sí, no tengo permiso.
No, I don't have any permission.
Are you in this country with or without permission?
Without permission.
What happens if you go to jail?
O sea, si usted va a la cárcel.
No soy ilegal, no puedo hacer nada.
I'm illegal, I can't do anything.
What happens if you go to jail, Mr. Ponce?
No, pues nada, estoy entre la ley, no puedo hacer nada.
I'm outside of the law, I can't do anything about it.
I don't know what kind of answer that is, Mr. Ponce, but I would hope that you would recognize that it's damn elementary that you're not supposed to have alcohol in the car while you are driving. And I'm telling you now, that is a minimum of 5 days in jail. 5 days in jail that you go to as a minimum to any
Cinco.
sentence you get on the
amigo.
DWI. And I will tell you that if you do anything more than 4 hours in a jail cell, immigration sweeps it on a daily basis. And if they find you, they will put an immigration detainer on you, and you will be stuck like Chuck in custody until the case is over with, and then you get shoved off to immigration, where you were sit for another 6 to 9 months, waiting for immigration to do what they're going to do. That is what happens when you violate the law and you go to jail.
Va a la cárcel.
Do you understand?
Sí.
Yes.
I am warning you at this moment not to drive at all for any reason, and you will be signing a promise with me. This is the only warning that you will get, Mr. Ponce, and this is an affidavit. If I find that you violate this, you can look forward to up to 6 months in jail and a $500 fine every time you drive, because I can have a contempt hearing. I'm also ordering you not to consume alcohol or illegal drugs, and I will randomly test you. If you consume alcohol, likewise, you will go to jail. No more PR bonds. The only reason you got out so quick is we gave you a PR bond. You violate conditions, pick up a new case, it will not happen again. Do you understand?
Yes.
What happens if you go to jail?
No, pues no sé.
I don't know.
Did you not hear anything that I just told you?
Nada de lo que le acabo de decir.
Sí, le escucho muy rápido.
Yes, I did hear it. It's just I heard you very fast.
What will immigration do to you?
Que le hará migración.
No, pues me voy a deportar.
O they'll deport me. Así es.
I will have you come up here, swear to us that you're not going to drive. After that, I will get you to Victoria. We will have you sign a reset. After that, we will get you to sign for your bond conditions. We will get you out of here. When you come back, have a lawyer, Mr. Ponce. Lori, you were here first.
Spanish, please, Your Honor.
Okay, come on.
Domingo Martinez, Your Honor. Page 17.
Please state your name, sir.
Jason Garrett.
Thank you. All right, Mr. Mansour.
Yes, Your Honor. Thank you for that opportunity to go into a breakout room. I've discussed with Mr. Garrett his options. He understands that if he sets a
This guy's kind of fun. It's quick, but it's fun.
for final settlement conference, there will be no offers going forward, and he would still like to set this for a final settlement.
All right. Final settlement is December 19th. 2024 at 11 a.m. Jury selection is January 3rd, 2025 at 8:30 a.m.
Well, you just said 2 different days. I'm confused.
One is settlement conference day, sir. The other one is your jury selection day.
What's jury selection?
You need to talk to your attorney about that, sir.
We'll talk to you about it, okay, Mr. Garrett?
I didn't ask for a jury.
I understand. That's if it gets to a jury.
Okay. So the final settlement is January, right?
No, final settlement is December 19th, sir. December 19th for the final settlement, January 3rd for the jury selection. So if it gets to jury selection date, that'll be on January 3rd when you pick your.
Okay. I think I understand now. All right, thank you.
You are.
Good morning, sir. Are you Gary Lee McKenzie?
I am.
I'm Judge Middleton. I'm here today covering things. Also with me is Mr. Larry Wescombe from the Public Defender's Office. You got picked up on an old warrant.
This is kind of a weird charge, the way it plays out.
Correct.
It's alleged that on or about September 5th of 2022, that you damaged some valve stems on some tires that belonged to another person. Let me take it to the actual thing. That person is Victor Ridenour III. It's alleged you injured some tire valve stems that he replaced from a junkyard at the cost of $117. So they charged you with misdemeanor malicious destruction of property under $200. That is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Mr. Wescombe is here from the Public Defender's Office, but let me ask, how do you wish to plead to that charge?
Well, not guilty, but there's a story with it.
All right, well, we'll save that for a minute. He alleges that you put an obscene note on his window, cut his tires over some previous dispute. Amazingly, the sheriff's department seized some of this evidence and sent it to the crime lab after they got a DNA sample from you, and the crime lab matched your DNA to some of this evidence. So that took months and months and months. It didn't come back until June 20th of 2023. So apparently your DNA is on some of the evidence. So they issued the warrant in July of 2023. And here we are in November of 2024. How did you get arrested?
I got picked up by a DNR officer for trespassing.
Last night?
Yeah, Friday.
All right.
But I was hoping that I could get a PR bond on this because I've got some other stuff in Indiana I need to get taken
Yeah,
care
you
of.
got a charge in Noble County, Indiana. Tell me about that.
That's weird.
I got pulled over. I borrowed a guy's coat. I got pulled over and there was paraphernalia.
Just tell me what so is this some sort of a drug charge?
Yes.
Okay, so he's messing with valves. Then he gets picked up by the DNR, which is Department of Natural Resources, which means he's out in the woods somewhere where he shouldn't be. And then he's got a drug charge in Indiana. This guy gets around.
Yeah, that's quite common. I borrowed somebody else's coat. But anyway, you have a hold on you from there. This thing originally had $100 bond. As I said, they do have some sort of DNA match to some of the evidence. But it's not the crime of the century, and it's almost a year and a half old.
Well, and then Victor,
in fact, it's 2 years old. All right, I'm gonna give you a PR bond. I'm gonna show a plea of not guilty.
Thank you.
I'm gonna appoint an attorney and set an attorney pretrial for December 6th
Okay.
at 8:30. Now, that presumes that you'll be bonded out of Noble County by then. What was the drug in the coat? Methamphetamine or some sort of opioid?
Yeah, it was some kind of a pipe or something.
All right.
There was no drug itself. There was a pipe that was dirty or something.
All right.
It's cute how he acts like he's confused about what it was. I don't know. I guess they're saying it's a pipe or something.
Well, I'll let you go down there and sort that out. All right, I'm going to appoint an attorney, set a pretrial for December 6th, 2024. The bond is $100 cash or surety. I'm just going to reduce the bond
Yeah, I've been
to
trying to get all the
$100
originals.
PR. You got arrested on Friday, November 1st. So 1, 2, 3, been in jail 3 days at this point.
So yeah, I need to get down to Indiana and take care of that.
Do you still live on Forest Street in Sturgis?
Yes, sir, I do.
All right, are you gonna have some sort of DNR trespass charge? You don't know yet.
Don't know yet. They said they would contact me if it went any further.
Where was that? Here in St. Joe County?
Yeah.
All right, $100 PR bond. I've set a attorney pretrial for December 6th. We're gonna give you the paperwork regarding your attorney's name and number. I want you to call that attorney, make an appointment to discuss that with them. Hopefully, if it's just a pipe in Noble County, you can go down there and deal with that and be out
Yeah.
by the time of your hearing on December 6th. All right, sir, you're good to go.
Okay, thank you.
Thank you.
No, Michelle, please unmute.
What
This one's fun. This hearing should annoy everybody.
case?
Schaefer versus Schaefer.
Okay.
Michelle, can you hear me?
I can hear you. Can you hear me?
Yes. 2021-2055 DS, Michelle Schaefer versus James Schaefer. Today is Monday, November 4th, 2024 at 9:10 a.m.
Court will note the appearance of Mr. Sullivan on behalf of the defendant. This matter is before the court on the defendant's motion for parenting time. Mr. Sullivan.
Thank you, Your Honor. The motion is fairly straightforward and presents the fact and law upon which it's based. The essence of it is that there is a order in place that does not provide a specific parenting time schedule for the defendant, and the decisions as to when parenting time will occur therefore are left to the voice of the person who has primary physical custody, which is Ms. Schaefer. We did receive what I believe Ms. Schaefer presents as her answer to the motion over the weekend. It was in the mail that came in over the weekend. I shared it with my client. My client vehemently disagrees with most of what's in there. But I did want to point out one piece of information that is in Exhibit A, and it's a text message from Ms. Schaefer to Mr. Schaefer, in which she writes,
Oh, she is.
"If you ever refer to me as not parenting my 2-year-old correctly again, I will discontinue visits because of rude comments." That really kind of illustrates why we're here today. That's not the type of exist when awarding parenting time to a parent. As the court knows, the law is based on the presumption that parenting time with both parents is in the best interest of the child in a meaningful way and with significant duration. So That's why we're here, Judge. We would expect to have a hearing on this issue and let the court make a decision about the degree to which the schedule should be defined.
Okay, thank you. Ms. Schaefer, what's your,
Am I unmuted?
yes,
Okay. Yeah, I looked over the motion that he presented, and I did want to state for the court record that I did receive the motion in the mail last Saturday. I have been trying to contact Mr. Sullivan because today I have seven appointments today, and I'm in my car. I asked for him to adjourn so that I would have more time to prepare. And obviously he didn't get back to me. So I am just going to go at this. I have I have consulted over the original order. I've consulted the caseworker Samantha Farrakasi and Margot Cummings and Highfields that help integrate me. And because of the nature of our situation and me having to supervise parenting times at times, it is very uncomfortable. And so there are issues. And I did submit that to the court, that exhibit, because it was just, it was bizarre. And there were words exchanged without children present in the house. And I was frustrated because I'm trying to obey court orders, uphold court orders, but yet give him room to be with the kids and be flexible in things. And I was advised by my legal advisors that because of the order, the way it's written, that I have physical and sole custody, or physical and legal custody of the kids. If we cannot come to an agreement, or there are escalations that have happened at parenting time, that I have the right to discontinue parenting time for a time if we cannot agree. And so I did, I'm trying to find that. I was upset because he did come down pretty hard on me, that I let my children rule over me, and it was just very uncalled for at that time. So I think that you've probably read through the affidavit that I submitted, and at this time, I do think that each parent should have a right to the children according to what the law states, but I also do think that it is in the best interest of the children to be protected physically, mentally, and emotionally. And the things that are said to the children at parenting time lead my older children are disturbing. And I think that you've read through the affidavit. I'm very concerned. I have lots of concerns, obviously, that we don't have to go over today. But one of my main obvious concerns is that this didn't just happen yesterday. The reason why we were here in court to begin with, the children's mental and emotional stability and physical stability is one of my main concerns in life. That's why I've been a stay-at-home mom for almost 25 years. I did want to what is disturbing is his comments about women and the religious factor that factors into our case. He's mentioning to the girls in front of the boys, which is a concern for all of us, that, you know, women need to be submissive to men in all situations. If not, they need to be punished. He actually had discussions with my daughters about how he doesn't believe women should be allowed to vote. He did this in front of everyone, even the small children could hear. And so it's things like this that really mess with people's heads. They mess with the children. Children don't know how to process this. It's detrimental. So I do have concerns. I have issues.
okay. That's understandable, and we'll address those issues at a hearing.
Oh.
What the court's going to do is the court is going to refer this to referee for a hearing on parenting time.
She's got issues. I agree with her there.
And you'll be contacted by the referee probably within a couple weeks, a week and a half or so, to set up that particular hearing, and then you'll have an opportunity to present all of your evidence at that time. So that's what we'll do, and we'll get that prepared and out, and then you'll be contacted by the referee. So free to go today. Have a good day.
Thank you,
Thank
Your
you,
Honor.
Start with Ms. On the record in state of Michigan versus Pollyanna Alford, 2303554 SM.
I might be a little sadistic, but this one's fun.
Assistant Public Defender Joseph Hardy on behalf of Ms. Alford.
And you, Pollyanna Alford. Louder.
Yes, yes, Your Honor.
Today is the date for probation violation hearing. Ms. Alford, when you entered your plea in this case, it was to an offense punishable by up to 93 days in jail. So if you're found to have violated your probation, you face up to 93 days with credit for any time that you've already served. You have the right to have an attorney. Mr. Hardy's representing you. You have the right to have a hearing where it must be proven by a preponderance of the evidence you violated your probation. You should also know if you violated your probation, you could lose a special status that keeps this off your public criminal history. It will be added to your public criminal history. The alleged violations today are contained within two show causes. One is failure to report to probation March 14 of 24, failure to submit to your analysis March 8 of 24, failure to enroll in domestic violence programming, failure to contact your probation officer for more than 60 days, having absconded from probation. So that is 1, 2, 3 types of
Just
violations.
lots of failure.
Mr. Hardy, how are we going to proceed?
At this point, Ms. Alford would like to admit to the violations, Your Honor.
Ms. Alford, you understand that if you plead guilty to these violations, you'll give up your right to have a hearing on whether you violated?
Yes, Your Honor.
You also have a recommendation from probation as to how you might be sentenced, but that's a recommendation. The sentence is what I decide.
There will be two.
I'm
Do you
fine.
swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
I do.
Ms. Alford, you were sentenced in this court to a term of probation in January 2024. You remember that?
I do, yes.
And as a condition of your probation, you were specifically ordered to report to probation as directed. You remember that?
I do, yes.
And is it true that you did not report in March of 2024?
That's true, yes.
Okay, oops, I skipped a set of violations. Not realize I had an additional set of violations. Before we proceed, I guess I better tell you what these say. Failure to report to probation in April. Consumed alcohol on or around May 4 of 2024. Made contact with the protected person around May 4 of 2024. Displayed assaultive or threatening behavior on or around May 4 of 2024. Now that I've covered all of the violations, I hope, Mr. Hardy, are you aware of any additions to the record?
No, Your Honor. Let's get one moment.
Okay.
So, my apologies. So, Ms. Alford would like to admit to the first set of violations regarding the failing to report, failing to enroll in the domestic violence program. Regarding the violations that involve appear to be new charges with.
Are there new charges though? Their Lansing Police Department report, as far as I can tell, well, I don't know for sure, but
Yeah, David, I
says
watched
May
it live.
4, and there's no new charges in
As it was
JIS,
broadcasted.
So I guess.
I don't know.
I guess I would be willing to hold violation number 12 and 13, making contact and assaultive or threatening behavior in advance. But I would want to address the failure to report in both March and April, the failure to do testing, failure to enroll in the programming, as well as the consumption of alcohol and the absconding.
And we'd be satisfied with that, Your Honor.
Okay. Ms. Alford, that's acceptable to you?
Yes, Your Honor.
So that adds 2 additional technical violations, which essentially make up the failure to report to probation in March and April end up making up the absconding in the end. But, all right. 13. All right. So we'll continue as I asked you. You were on probation and you understood that you were to report to probation. Did you fail to report in March?
Yes, I failed to report.
And you failed to report in April as well?
Yes.
Okay. You were also ordered to submit to testing to prove your sobriety on probation. Is it true that you failed to test in March 8 of 2024?
Yes, Your Honor.
You were ordered to enroll in programming to address the domestic violence. Is it true that you failed to enroll in domestic violence programming?
Yes, Your Honor.
Is it true that you consumed alcohol on or around May 4 of 2024?
Yes, Your Honor.
Oh, thank you.
Looks like there came a point where you just stopped reporting to probation altogether.
Yes, Your Honor.
So you absconded. Is that yes?
Yes, Your Honor. I'm sorry.
Did anyone make any promises or threats to you in order to get you to plead
Coming
guilty
right up.
To these violations?
No.
Are you pleading guilty of your own free choice?
Yes, Your Honor.
Find a guilty plea to be knowingly, voluntarily, accurately made with sufficient facts on the record upon which to base your plea. It's therefore accepted. That's 5 technical violations and absconding. Mr. Nagel, do you wish to be heard on sentence?
Defer to the court, Your Honor.
Mr. Hardy?
Thank you, Your Honor. Ms. Alford knows that, she made a bad decision by not reporting and failing to do her due diligence. However, we would just ask that consider her, that you consider that for this underlying case that she did not have a habit or routine of being a violent person. She understands her mistakes, and we just ask that she be given another chance on probation with perhaps with more oversight. Just give her a chance to
You'll never believe it. She blames it all on a guy.
get her the help that she needs regarding both her emotional regulation and her relationship with substances.
Ms. Alford, what would you like to tell me today?
I just want to do the right thing. I do feel bad, and I am sorry for what I've done. There's no excuse for my actions. I will stay far away from the toxic relationship altogether. I realize that
There's no excuse, but it's some guy that I have a toxic relationship's fault with.
that's what's got me here. I just want to get back to my kids. But all in all, I do apologize, and I want to do the right thing, and I want to get my life back together.
That's my job.
Ms. Alford, there was a series of choices to be made along the way, right?
Yeah.
So when you're arrested for whatever's happening with Bianca, that should have been your cue.
That was me turning myself in. I called them.
That wasn't my point. You're accused of a crime involving Bianca. That should have been your cue to do something different, right?
Yes.
Then you get put on probation. That should be your cue to do something different.
Yes.
You failed to appear for your probation violation arraignment in April of 24. You get arraigned by the magistrate. Should have been your cue to do something different. But instead, in May, we don't see you again. It's not like you suddenly came in to see probation and were like, I want to pick up. I want to do the right thing at that point. No, you still didn't. You still went on the run until you got picked up October 28. You've done nothing on your probation. I have no choice but to revoke your 769.4A as you pled guilty to a violation involving failure to attend counseling that was intended to address your assaultive behavior. Probation is therefore revoked as well. 60 days jail, credit for 14 days. You do still owe the court money. You must report to our collections department when you finish your jail sentence to make arrangements on the payment. You don't have to have money in your pocket to come in and say, I expect that I'll be able to afford X beginning on, whatever date. Since I gave you jail, you have the right to appeal my sentence. If you need a public defender to assist, you need to make your application within 14 days. Ms. Alpert, I don't know why it took so many times
It was
for
a
you
wake
to
up call.
come into the system for you to realize something had to change. But when you're under a court order and you're told to do certain things,
yes,
it is a court order. You have to do those things. It's not for you to decide what you are and aren't going to do. It's not for you to decide you're going to drink alcohol. It's not for you to decide that you may or may not choose to have contact with a prohibited person, to refuse to go to counseling. It's not for you to do. If you ever come under the
That's my
jurisdiction of
IG.
court again, which God forbid, I hope you never do this again. You got to do it a whole different way. That's a lot to you, Michelle.
Oh, man, I gotta get together.
The wheels of justice are going to roll you right into the Wayne County Jail.
Well, there you go. That's what I got this morning. Good stuff. I think there's more on the way based upon the chat. Looks like there's fun stuff happening. Thank you all for coming out. I appreciate it. Let me see. Get down so I can see. All right. Thank you. I will see you all soon.